for 55 of the last 60 years. This year, the federal government will bring in more revenue than any year in the history of our government, and yet we will still have nearly a $700 billion budget deficit. We have a spending problem. It must be addressed, period.
Delaware.
Madam President, I know you're familiar with the phrase.
Oh, excuse me. Senate is in a quorum call.
Madam President, I ask unanimous consent that proceedings of the quorum call be vitiated.
Without objection.
Madam President, I am confident you are familiar with the phrase, justice too long delayed is justice denied. Dr. Martin Luther King, Jr. wrote that from his jail cell in Birmingham. Justice too long delayed is justice denied. Madam President, I rise today to talk about justice and the budgetary choices Congress is making that impact the American people's ability to access the justice promised them by our Constitution. Our federal courts translate laws into justice, and effective courts require fair judges, well-trained lawyers, and efficient clerks. As you well know, the fewer judges and clerks you have, the reduced resources in time-saving technology, the fewer cases can be handled at a time, and the longer cases will take to process. Justice too long delayed is justice denied. Of course, staffing our courts costs money. But when you compare it to the rest of the federal government, this whole branch is a relative bargain. For every $100 spent by our federal government, just 19 cents go to the entire federal court system. We actually spend more every month on the ongoing conduct of operations in Afghanistan than we do in an entire year on the whole federal court system. It is, relatively speaking, a bargain. With caseloads growing and budgets shrinking, though, the federal courts have been cutting back where they could for years now, methodically looking for ways to cut costs, reduce overhead, lower their personnel, and generally be more efficient. They are both metaphorically and literally looking under every cushion for coins, whatever they can do to keep up. Then came the sequester. Of course, when it was first conceived, the sequester was designed to be so reckless, so dangerous, that it would drive Congress back to the negotiating table, House and Senate Republicans and Democrats, to confront our nation's annual deficits and craft a bipartisan bargain. But sadly, it failed. Congress as a whole failed, and the across-the-board spending cuts engineered in the sequester went into effect. It's been almost 7 months since they came into effect, and in that time I've heard from hundreds of Delawareans, as I'm sure all the members in this chamber have heard from their constituents. I've heard from Delawareans directly impacted by the sequester. Dumbfounded civilian employees of Dover Air Force Base, more than 1,000 hardworking Delawareans. Many of them veterans who can't believe that they individually are paying the price because Congress, House and Senate Republicans and Democrats, can't craft a responsible deal. Kevin from Magnolia asked me, why are my family and I being punished with a 20% pay cut this quarter? Brian from Houston, these are both towns in Delaware, said he was tired of being the one to suffer the consequences because, in his view, Congress can't get the budgetary job done. My heart goes out to Kevin and Brian and every Delawarean who's called my office, written to me, talked to me about the sequester. I agree with them. It needs to be replaced responsibly and urgently. And as a member of the Budget Committee, I've worked with my colleagues to craft a budget that would replace sequester in a way that's in keeping with our core values and the priority of investing in America's future. Not many people, though, are talking about how the sequester is impacting our courts. We hear how sequester is affecting defense, we hear how it's affecting research, we hear how it's affecting infrastructure, but our courts have often gone without consideration. There's no natural constituency, bluntly, that feels slighted. The number of furloughed employees is relatively small, and there is no real lobby in Washington for the health of our courts. But the sequester's impact on federal courts affects all of us, every single American. The sequester is slowing the pace, increasing the cost, and eroding the quality of the delivery of justice in this country. At the end of our last session, I chaired a hearing of the Senate Judiciary Subcommittee on Bankruptcy in the Courts, which I chair, and looked at how the sequester is impacting the public defender service in our nation's courts. These courts have been forced broadly to go past the fat and well into muscle and soon into bone. The judiciary has looked at a variety of measures to address this new budgetary reality, and very few come without significant pain to the businesses, the individuals, the communities that rely on our courts. One proposal, to simply not schedule civil jury trials in September, would effectively impose a 30-day uncertainty tax on every civil litigant. A judge in Nebraska has threatened to dismiss so-called low-priority immigration status crimes because of a lack of capacity. In New York, deep furlough cuts to the public defender's office caused the delay of a criminal trial for Osama bin Laden's son-in-law and former al-Qaeda spokesman. In my home state of Delaware, sequester has meant lengthy employee furloughs at clerks' offices and reduced investments in IT and postponed essential upgrades. Simply put, the financial state of our federal courts erodes our fundamental constitutional rights. Individuals depend on the courts to be there when they need them, to seek relief from discrimination, to resolve commercial disputes, to enable parties to stop fighting and get to work growing the economy, or to guarantee fairness and efficiency in criminal proceedings. The reality is our federal courts were already stretched thin before this sequester. Chief Justice Roberts leads the Judicial Conference of the United States. The Judicial Conference was created by us, by Congress, to administer the federal court system and work with Congress to ensure appropriations keep up with the needs of our courts. The Judicial Conference is and always has been nonpartisan. Earlier this year, the Judicial Conference sent Chairman Leahy and me a letter recommending that in order for the courts to fulfill their missions, we must add federal judges to the bench. In the last 2 decades, since the last comprehensive judgeship bill, 23 years to be precise, Article III district courts have seen their caseloads grow nearly 40%, yet the number of judges has grown by 4. Today, judges in the Eastern District of California, long recognized as one of the most overburdened in the nation, face over 1,000 weighted case filings per judge. In the District of Delaware, case filings are over 1,500 per judge. The Judicial Conference generally believes additional judgeships are needed when there are more than 500 per judge. So even before the sequester, our courts weren't keeping up with their caseloads. Heeding the recommendations we received last month, Chairman Leahy and I introduced the Federal Judgeship Act of 2013, which will create 91 new federal judgeships, 2 federal circuits, and 32 judicial districts across 21 states. This bill would provide needed relief to our overburdened courts, ensuring they are better prepared to administer justice quickly and efficiently. Again, this proposal, this bill, is in direct response to the analytical work of the nonpartisan Judicial Conference. Madam President, this change is long overdue. Congress has not comprehensively addressed judicial staffing levels since 1990, 23 years ago, and the court-weighted filings per judgeship have risen from 386 back then to 520 today. Those national figures actually mask even more dramatic circumstances faced by the most burdened districts in Texas, in Delaware, and in California. Yesterday, I chaired a hearing of the Senate Judiciary Subcommittee on Bankruptcy in the Courts to consider this act. And during this hearing, District Court Judge Sue Robinson of Delaware testified on the need for more judgeships. She explained that despite all the additional technologies we have and an excellent staff, there's nothing more I can do, she said, at this point with respect to getting my cases timely resolved. At that hearing, I appreciated and was encouraged by my colleague, the senator from Alabama's statement that, in fact, the District of Delaware deserves another judge due to its incredible caseload. I would argue, though, and the evidence suggests, that the need is not confined to my state, but to districts all across the country. We need to take on the whole problem, Madam President, not just a small piece of it. Nobody wants to be in a courtroom, but when you need to be in court, it's because something significant has happened in your life, and you don't want a judge rushing to move on to the next thing because of a crushing caseload. You don't want clerks so awash in paperwork that yours gets lost. In conclusion, we need to help our judges deliver justice by replacing the sequester with a responsible, balanced approach that restores funding taken from our courts and allows us to add the judgeships we need to keep pace with demand. Dr. King was right. Justice too long delayed is indeed justice denied. By delaying the delivery of justice, the sequester is denying justice to too many Americans. We don't need more delays. We need more judges. And we need to act together to get it done now. Thank you. And with that, I will yield the floor.
Madam President.
Senator from New York.
Madam President, I ask unanimous consent to set aside the pending amendment and call up my amendment 1860 to the Energy Savings and Industrial Competitiveness Act of 2013.
Madam President.
Senator from Louisiana.
Madam President, reserving the right to object, I certainly support a vote on that amendment, many other amendments, all amendments, my amendment, and therefore I propose an alternative unanimous consent request I ask unanimous consent that the pending amendment be set aside and the following amendments be made pending. Gillibrand, number 1860. Franken, number 1855. Inhofe, number 1851. Bennett, number 1847. Udall, number 1845. Klobuchar, number 1856. Sessions, number 1879. Enzi, number 1863. And Vitter, number 1866. And that on Tuesday, September 17th, at a time to be determined jointly by the majority and minority leaders, that my amendment number 1866 and a side-by-side amendment on the same subject by the majority leader be made pending and receive 60 minutes of debate, evenly divided and controlled by the majority bill manager and myself, that no points of order be in order in relation to these two amendments, that upon expiration of the time for debate without any intervening motions or debate, the Senate then proceed to votes on these two amendments, subject to a 60-vote threshold for passage, and that subsequent to each amendment vote, a motion to reconsider each vote be made and laid upon the table.
Is there objection to the amended request?
I object.
Objection is heard.
Madam President,
Is there an objection to the original request?
Madam President, reserving the right to object, let me offer another alternative, because again, I want this amendment to be voted on. I want all the amendments I mentioned to be voted on. I want my amendment or issue to be voted on. And so, in that spirit, Madam President, I ask unanimous consent that I be allowed to withdraw my Vitter amendment number 1866, and that on Wednesday, September 25th, 2013 at 3 p.m., the Senate discharge the relevant committees from consideration of my related bill, the No Exemption for Washington from Obamacare Act. Proceed immediately to consideration of my bill, and that without any intervening motions or debate, the Senate proceed with 60 minutes of debate on the bill, evenly divided and controlled by the majority leader and myself, and that the bill not be subject to any amendments or motions to commit, and then after debate has expired, the bill be engrossed for third reading, read a third time, and the Senate immediately vote on final passage subject to a 60-vote threshold, and that the motion to reconsider be made and laid upon the table.
Is there objection to the modified request?
I object.
Objection is heard. Is there an objection to the original request?
Well, Madam Chairman, in that case, I must object, and I regret that we can't choose these paths forward, which would ensure the vote on these amendments that we're discussing. Thank you, Madam President.
Objection is heard.
That's just for debate. I don't have
Senator from New York.
Madam President, I have an amendment that will help anyone in America that has had to rebuild after a natural disaster, and I really hope that we can break this impasse and it can soon be considered. My amendment would remove burdens and streamline the process that recipients of disaster aid face when upgrading to more energy-efficient technology. In the wake of Superstorm Sandy, we saw all too well that old technology can fail all too easily. Yet because of administrative burdens, recipients of much-needed emergency funds will replace appliances and infrastructure with the same antiquated counterparts that were damaged. In many cases, this means replacing a 10-year-old hot water heater with another 10-year-old unit, or replacing a 20-year-old electric transformer with similarly antiquated systems without any regard for modern safety and efficiency standards. At a minimum, we should provide the option of allowing these homeowners, businesses, and utilities the ability to use emergency disaster funding to upgrade to more energy-efficient appliances, machinery, or electrical infrastructure. Not only will the use of energy efficiency technology save money, it reduces pollution, it creates jobs, and it will help ensure that our infrastructure is more resilient to the increase in extreme weather events we have seen facing this country. My amendment allows emergency funding recipients to voluntarily upgrade damaged equipment and structures with energy efficiency technology. It's a budget-neutral alternative to current law. It does not direct FEMA to spend at higher levels. Remember, every dollar spent in upgrading to more energy efficiency technology provides upwards of $5 in savings. we should be streamlining the process and removing the roadblocks individuals and businesses face when choosing to replace items destroyed in natural disaster with more energy efficiency technology. Thank you, and I do hope that we can consider this amendment soon.
Mr. President,
Senator from Oregon.
just to respond to the distinguished senator from New York, I want her to know that I am very hopeful that we'll get your amendment formally in front of the Senate. And I want the senator from New York to know, and colleagues to know, that I think Senator Gillibrand has brought a first-rate idea to this already bipartisan bill. And here's what Senator Gillibrand is talking about, because I know energy is sometimes a little bit of a complicated, area. What Senator Gillibrand is essentially saying is that she wants to give folks who've been clobbered by a disaster more choice in how they rebuild after a disaster. In effect, what the senator from New York is saying is, let's give those folks who've been hard hit by disasters a chance to trade up for those energy-efficient products that are going to save them energy and save them money. This is the kind of idea, colleagues, that sometimes seems too logical for Washington, D.C. But it sure makes a lot of sense to me. I commend the senator from New York for offering this particular idea. As she's indicated, no mandates. This is not the federal Leviathan, sweeping in and forcing people to do X, Y, and Z after a disaster. This is about choice. It's being done without any extra money provided by the government. I think it's just a first-rate idea. And frankly, this is what Senator Shaheen and Senator Portman and I thought would be part of this debate. It's been so long since anybody really got serious about this issue on the floor. We were convinced that people would start bringing good ideas to the floor. In effect, that they've been welling up all this time when we haven't had energy efficiency on the floor. So we've been here for a day and a half. I sure wish we were voting on my colleague's amendment and other amendments relating to energy efficiency. I think it's an excellent idea. I hope colleagues will support it, and I yield the floor.
The senator from Louisiana.
And, Mr. President, let me just echo, I hope Senator Gillibrand gets a vote. I hope all of these amendments I mentioned get a vote. And, of course, I hope my proposal gets a vote. The distinguished majority leader several days ago announced that the floor was open for amendments. No limitations except one which we all agreed to put the Syria debate on hold, as the President asked, and everyone agreed to that. And the majority leader said this would be an open amendment process. The floor was open for any and all amendments. Well, great. Let's have it. Let's have votes on all of these amendments, certainly including Senators Gillibrand, Franken, Blumenthal, Inhofe, Bennett, Udall, Klobuchar, Sessions, Enzi, and my amendment. And again, Mr. President, the vote I'm asking for, well, quite frankly demanding, doesn't have to be in the context of this bill. As I've made clear with my second UC request, I will put it aside and withdraw it from this bill. But it is time sensitive. It does have to occur in a fair up or down way before October 1st, because the illegal OPM rule, that's a bailout and exemption for Washington, takes effect then. It is very time sensitive. Now, I didn't create that rule, certainly, and I didn't create that timeline, and therefore I didn't create that urgency. But it is there because of that, in my opinion, illegal OPM action. So I will also happily accept that vote outside the context of this bill, and I have suggested multiple paths forward where we can vote. So let's vote, but everybody needs to get reasonable votes, not just those who are approved by the majority leader. So I look forward to that resolution. I put multiple paths forward and look forward to that being resolved in the near future. Thank you, Mr. President.
South Dakota, right? Senator from South Dakota.
Mr. President, I'd like to speak to a couple of amendments that I have filed to the bill that's under consideration by the Senate today. And I want to talk about Amendment number 1876. And just to kind of give you the background, the context on this, most of us know that when we were debating the health care bill a few years ago, the labor unions were enthusiastic supporters of Obamacare. And it perhaps should come as no surprise that they're having some buyer's remorse. I think they're realizing they were sold a bill of goods. And like a lot of people around this country that I talk to, they would like to have a do-over. In fact, if you look at what's happened since the legislation has become law and what's happened to premiums, they continue going up. In fact, there was a Kaiser study just this last month that had premiums, family premiums going up $3,000 on average since President Obama took office. And of course, that was after the promise that health care premiums were going to go down by $2,500. You've seen employers either cut jobs or slash hours. In fact, 250 employers have cut jobs, and there's hardly a day that goes by where there isn't a headline in a major newspaper about some employer that is having to reduce their workforce or not hiring people they otherwise would hire simply because of the additional costs, the requirements, the mandates, all the uncertainty created by Obamacare. And of course, what that means is the people who are getting hired for part-time jobs. If you look at the number of jobs that's been created this year, about 77% of those are part-time jobs. What's happening? Well, a lot of employers, those who are under 50 employees, if they go over 50, obviously they're covered by the mandate that says that they have to provide government-approved health care, so they're keeping the number under 50 employees. And then the other requirement is that to qualify as a full-time employee, you have to work 30 hours a week. So employers are also reducing the hours of their employees. So we've got more now 29-hour-a-week jobs in this country, I think, than we've ever had before. And the numbers since the beginning of the year with regard to jobs created, part-time jobs, really do bear that out. More and more employers are finding their way to reduce hours of employees and hire people for jobs that are part-time jobs as opposed to full-time jobs. What does that mean? Well, that means that the take-home pay of middle-class Americans is going down. And in order to make ends meet, they're now having to get that second job. And so it's creating all kinds of the distortions in the labor force. And so it's no surprise, I would think, that the labor unions would like to have this issue revisited. And I want to share with you something that a couple of statements that have been made. The International Brotherhood of Teamsters, UFCW, and Unite Here. This was a letter to House Minority Leader Nancy Pelosi and Senate Majority Leader Harry Reid sent in July on behalf of the millions of working men and women we represent and the families they support. We can no longer stand silent in the face of elements of the health care law that will destroy the very health and well-being of our members, along with millions of other hardworking Americans. The United Union of Roofers, Waterproofers, and Allied Workers is, and this was from a letter several months ago in April, I am therefore calling for repeal or complete reform of the Affordable Care Act to protect our employers, our industry, and our most important asset, our members and their families. And if you look at the letter that was sent July 11th by the three unions I mentioned earlier, it goes on to say that it will create nightmare scenarios, it will shatter benefits, and actually that it will destroy the backbone of the middle class, which is the 40-hour work week. And so very strong language by some of those who are the most enthusiastic and strongest advocates and supporters of Obamacare when it was being discussed and debated here in the Senate. And last night at their annual convention, the AFL-CIO passed a resolution calling for major changes to Obamacare. Mr. President, the unions are trying to get a special deal, and they want to work with the administration in a way that completely ignores the text of Obamacare. The law says that anyone that has an offer from their employer of a government-approved health care coverage is not eligible to go into the exchanges and receive refundable health care premium tax credits. The law also states that union-provided insurance known as Taft-Hartley multi-employer health plans is government-approved health care coverage. Consequently, union employees enrolled in these Taft-Hartley plans are not eligible for the exchanges and the refundable premium tax credits that are available in the exchange. Well, obviously, the unions are not happy about that. In fact, on August 27th in 2013, the trade publication Inside Health Policy reported, and I quote, "The Office of Management and Budget previously showed on its regulatory review website that on August 24th, it received a Department of Labor proposed rule on health insurance premium assistance trust supporting the purchase of certain individual health insurance policies. The rule, which OMB said is Patient Protection and Affordable Care Act related, also appears to deal with the exclusion from a definition of an employee welfare benefit plan, but this week the description disappeared," end quote. The unions are clearly seeking a way around the law and want a special fix that would apply to them and to them only. If they have their way, Mr. President, what essentially happens is that union members will receive government subsidies for their insurance plans from 3 different sources in 3 different ways, a benefit position that no other organization or individual is in. First, they get the tax deduction that an employer receives for contributing to a union health plan. Second, they will get the non-taxable income that the employee receives when his or her employer purchases a union health plan. And 3, and finally, a new premium assistance tax credit for union members who purchase a union health plan. Now, recent analysis from the American Action Forum shows that if the administration gives labor unions what they want, it would cost taxpayers $187 billion over the next 10 years. The new health care law, Mr. President, is clear that taxpayer-funded premium assistance credits are intended for low to middle income Americans without access to affordable insurance through an employer or who purchase health insurance on the exchanges. The fact is that Taft-Hartley union health plans are not exchange-based plans, they are employer-sponsored health plans. Providing union members with a premium assistance tax credit on top of the favorable tax treatment already afforded to them for their employer-sponsored coverage amounts to double dipping for union workers and is grossly unfair to every non-union worker in America who would receive no such special benefit.
Be in order. Please proceed.
Mr. President, the law states that union employees should not receive both Taft-Hartley coverage and premium tax credits. But the administration's made it abundantly clear that they're willing to ignore this law in other areas. And that's why I've introduced as a bill and as an amendment to the pending legislation the Union Bailout Prevention Act that would seek to close off any possible loophole that the administration might create or could use to give unions a special fix. Mr. President, I don't blame at all the unions or other Americans around this country for not liking what they got. I think a lot of people had higher hopes, and those obviously who supported this and enthusiastically supported the health care law are now realizing that this isn't what they were promised. And as a consequence of that, a lot of them would like to see a do-over. They want to see changes. They want to see reforms. Some want to see a repeal. That obviously would be my preference in all this. But it is not fair to carve out groups of people at the exclusion or detriment of other Americans who would be unfairly impacted by that carve-out. And that is essentially what they're requesting here. They're trying to get special treatment that would allow them not to claim 1, not 2, but 3 special tax provisions or tax treatment as a result of the new Affordable Care Act, when in fact under Taft-Hartley plans they already receive favorable tax treatment, and they are in government-approved plans. That is a government-approved plan, therefore not eligible for the exchanges, as are many other Americans who don't have access to some sort of employer-provided health care plan. And so this would create, if this carve-out were something that the administration were to approve, it would create a special treatment, a special provision that would cost taxpayers billions and billions of dollars and be completely unfair to countless Americans who would love to see the provisions of this law either repealed or delayed for them as well. Now, the better solution, I would argue, is let's delay this for everybody. I'd like to see it repealed. I think we could have done a much better job. We didn't need a 2,700-page bill and 20,000 pages of regulations to deal with some of the challenges and problems that we have in our health care system today. But that's what we have. We have a government takeover of our health care system. We have 20,000 pages of regulations, which, by the way, is significantly taller than I am. It's about 7 feet tall when you stack those regulations. Somebody has to interpret all that. Somebody has to make sense out of it. And obviously, as people start to interpret and make sense out of it, they're not liking what they're finding. And that shouldn't come as any surprise, because when you get a massive expansion of the government, which is essentially what this was, a takeover of literally 1/6 of the American economy, you're going to have a lot of associated unintended consequences. And I think it would make a lot of sense, and there's so many better ways of going about this, if we were to repeal this and start over. But at a minimum, if one group is going to get special treatment, then all Americans ought to get that same treatment. And the best way to do that, I would argue, Mr. President, is to delay this for everybody across this country, not to create special carve-outs, special treatment that would apply to just a small number of Americans when there are literally millions of Americans who are impacted by this new law. Mr. President, I would also like to address briefly, if I might, and this is another amendment that I filed to this bill, and it has to do, it's amendment number 1887, and it has to do with the Department of Energy loan program that has already cost taxpayers millions in bad investments. It is the Advanced Technology Vehicle Manufacturing Program. It was intended to provide loans for manufacturing facilities that produce fuel-efficient vehicles. However, after making only 5 loans over the past several years, this program was mothballed in 2011. Remarkably, Secretary Moniz is considering reviving this program and is reportedly seeking new applications for the ATVM program. Now, Mr. President, I've introduced this amendment because the Obama administration has not proven itself to be a very good venture capitalist. If you look at the record of the 5 recipients of ATVM loans, 1 is bankrupt, another has suspended their payments on a $192 million loan. The Government Accountability Office has also questioned whether the Department of Energy has the expertise to properly assess loan applications. The GAO has also concluded that the Department of Energy lacks the engineering expertise needed for effective technical oversight. Mr. President, not only is this program poorly managed, it's no longer needed. Credit markets and the auto industry have largely recovered from the recession, and industry participants have shown little interest in the ATVM program in recent years. Additionally, stricter fuel economy standards, which automakers supported, promote vehicle technologies that are subsidized by the loan program. The ATVM program has $16.6 billion in outstanding lending authority, and according to GAO, that is a credit subsidy risk of over $4 billion. Now, I have offered this amendment to prohibit any new loans from being made under the ATVM program and to protect taxpayers from this outstanding exposure. Given the Energy Department's poor track record and the fact that these subsidies are no longer necessary, I would urge my colleague to support my amendment to stop the administration from making additional risky loans and losing even more taxpayer dollars. So, Mr. President, I hope that we will get a chance to vote on these amendments. I know that the manager of the bill, the senator from Oregon, is working with others to try and come up with a path forward in terms of processing amendments. But this is certainly one that, in my view, would save the government, the taxpayers, some money. And if you look at the record, I think that most Americans would agree this is not the way they want to see their money used. Mr. President, I yield the floor.
Senator from Oregon.
Mr. President, I ask unanimous consent the Senate proceed to a period of morning business with senators permitted to speak for up to 10 minutes each.
Without objection.
Yeah, no, I think we're... President.
Senator from Ohio.
Mr. President, I know you have some thoughts on this efficiency bill we're going to hear from later, and I appreciate that, and I want to thank Senator Thune and others who come to the floor to not offer their amendments officially because we have this issue we need to resolve on health care front, but to talk about good amendments to the legislation and ways to improve it. I know Senator Gillibrand from New York was out earlier talking about her legislation, which is a common-sense approach to ensure that as you do retrofits after natural disasters, that you can use more energy-efficient appliances and so on. So there's some common-sense ways for us to move the efficiency agenda forward with an all-of-the-above energy strategy. I think we've had a good debate today on that topic, and I think we've actually gotten, again, a number of amendments that have been proposed. I can count 7 of them that are bipartisan, that have been discussed here on the Senate floor. They're going to help us as we proceed in this bill. I'm hopeful that we will have votes on Monday and Tuesday on this, and that we can move forward with resolving the outstanding issues on the health care front to be able to move to the bill. I do hope that my colleague from Louisiana does get a vote on his health care bill. I think it's important. I think it's important the Senate be heard on that. But let's also be sure that we actually move forward with this underlying legislation. This is a unfortunately rare example of where Republicans and Democrats have come together here in the U.S. Senate to put forward legislation that's been worked out carefully, thoughtfully over time, that addresses one of the concerns we have as a country, which is that our energy that's used in our manufacturing facilities and by us as individuals and families, and certainly by our federal government, makes our economy less competitive, increases our costs, and there are ways to both make our economy stronger, certainly improve the environment, and also make us less dependent on foreign energy by moving forward with energy efficiency as one leg of really a combination of things that we need to do in an all-of-the-above energy strategy. Some of that, of course, should be producing more energy. In my view, I think this is a great opportunity for America, particularly in states like Ohio that I represent, where we have a tremendous opportunity to produce more natural gas, so-called wet gas. It's very valuable right now, and also oil, and that'll help to not only have lower energy costs, but more stable energy costs going forward to bring back manufacturing. And I think it could lead to a rebirth of some of the great industries in states like mine of Ohio, but also around our country to help to get this economy back on track as we face high unemployment and low economic growth. But along with producing more, we need to use less and use what we have more efficiently. To me, this is a conservative approach because we want to be sure that the energy we have is used most effectively and efficiently. We've seen a lot of gridlock on Capitol Hill recently on other issues. Again, this is one where we do have Republicans and Democrats who have worked together with the senator from New Hampshire. We've spent 2.5 years working on this. That's one reason we do have over 200 businesses supporting us. We have over 260 organizations ranging from the Chamber of Commerce who agreed today to key vote this legislation, to the National Association of Manufacturers on the one hand, the Sierra Club, the National Resources Defense Council, and other groups on the other hand. So it's an interesting combination of folks who believe that energy efficiency is low-hanging fruit. It's a way for us to use less energy, therefore have a more productive economy, have a better environment, and make us less dependent on foreign oil. This is an opportunity for us to do something else, in my view, which is to not just pass good energy legislation for the first time really in several years here on the floor, but also to provide a model of how we can maybe work on some issues that are even bigger than energy efficiency, like dealing with the debt and deficit and broader economic growth issues like tax reform. So I'm hopeful that we can move forward with this debate. I appreciate today people being patient as they came to the floor and waiting for their turn to be able to speak about their amendments. I also appreciate those who are trying to work out some sort of unanimous consent agreement with my colleague from Louisiana so we can move forward on the actual votes. I know we're going to hear from our colleague who is currently in the chair tonight and others this evening about energy efficiency, but I would just like to end by saying that there is a way for us to make progress on these issues. We've shown it by this legislation. Let's get through these procedural hurdles. Let's be sure that we can, in this instance, break the gridlock, get something done that helps my state of Ohio, helps the American people, helps us move forward in terms of better economic growth, a cleaner environment, and also a better national security situation where we're not dependent on these foreign sources of oil, sometimes from very dangerous and volatile parts of the world. As we've seen in the last several weeks, that's problematic. And there's a better way here. There's a better way forward. This energy efficiency bill is one of the steps we can take moving forward. With that, Mr. President, I appreciate again your work on this issue and look forward to hearing your comments later, and I yield back. I see my colleague from Ohio is on the floor.
Mr. President.
The senior senator from Ohio.
Thank you. I appreciate my colleague's words and his work with Senator Shaheen on a very important energy bill. And I know that the presiding officer, and if I could add, whose mother is in the gallery, we'll get to hear him in a few minutes. I guess I'm not allowed to add that, Mr. President. I apologize for that. I'm seeing a head shake. I apologize, Mr. President. I've been here long enough. I should know that. I rise, Mr. President, to speak today how our nation's efforts to combat tobacco products, the #1 preventable cause of death, how our nation's efforts are being threatened by a pending trade deal. Next week, the Obama administration will continue negotiations on the Trans-Pacific Partnership. It's called TPP. The TPP is a proposed trade agreement that currently includes the United States and about a dozen other countries. It would create a free trade zone among the member countries. Sounds good. Maybe it creates jobs, although trade agreements in the past have always been overpromised. There are real opportunities for workers and businesses in this trade deal if done right. But like any agreement of this size, there are lots of challenges, lots of issues that will require close examination by Congress and the American people. This sort of one-size-fits-all type deal with a broad set of countries, from rich countries like the U.S. and Australia to poorer developing countries like Malaysia to communist countries like Vietnam, is a challenging undertaking to integrate these economies in a way that works for us. Congress will have time to examine the details of the TPP as it moves along. But today, Mr. President, I want to talk about one specific part of this agreement that hasn't gotten the attention it deserves. In fact, the text of the TPP has not really been widely available except more to interest groups than it has the American public. But I want to talk about the U.S. proposal on tobacco products and how tobacco companies could challenge anti-tobacco efforts in the United States and abroad under this Trans-Pacific Partnership. We know big tobacco will stop at nothing to replace the thousands of customers they lose each year to lung disease. I remember, Mr. President, many years ago, and I'll talk a little more about this committee later, but we did a number of tobacco hearings when I was in the House of Representatives. And one of the things that was clear is that we talked about in those days, I believe the number 350,000, 400,000 Americans died from tobacco use every year. And the tobacco executives, when they came and talked to us, it was really clear of one thing. They understood 350,000 of their customers were dying every year, so they had to find 350,000 new customers every year. And where did they go? They didn't go to people of the age of the presiding officer or me or members of the Senate. They went to people the age of the pages sitting on the steps next to the chair of the presiding officer. They went after 14-year-olds and 15-year-olds and 16-year-olds because that's how they were going to replenish their customer base. Any business has a business plan to attract new customers, but when your business actually kills people, as tobacco does, 350 to 400,000 a year, it's something like the estimates now are slightly in excess of that. That business has got to figure out creative, in this case, immoral ways of getting young people to start smoking cigarettes. The 440,000 Americans that die from tobacco-related illnesses, making it the leading cause of preventable death in this country. It now includes 50,000 deaths, something we weren't so sure of 20 years ago, 50,000 deaths attributable to secondhand smoke. In Ohio each year, 18,000 people die from smoking, 2,100 adults die from exposure to secondhand smoke. Smoking kills more Ohioans than alcohol, AIDS, car crashes, illegal drugs, murders, and suicides combined. 20% of deaths in Ohio are attributable to smoking. Each year, 17,000 Ohioans start smoking. By the time they leave high school, many are addicted. 90% of adult smokers started before their 18th birthday. Of course they did. Not very many people start smoking when they're 25 or 30 or 40. Tragically, 293,000 Ohio children under the age of 18 alive today will ultimately die prematurely because of their smoking addiction. With the rise in electronic cigarette use among American teens, it's not a stretch that deaths of young people who use tobacco products may in fact increase. Just last week, the Centers for Disease Control and Prevention reported that the percentage of middle and high school Americans that use e-cigarettes doubled from 2011 to 2012, from 4% to 10%. I have no doubt that we'll find these devices to have their own negative health effects and that they'll serve as gateway devices to conventional tobacco products. You got to figure that's the hope of the tobacco companies. We know that tobacco-related deaths represent the #1 preventable cause of death in the world. Thankfully, we're making progress. We passed, President Obama signed into law the Family Smoking Prevention and Tobacco Control Act 4 years ago, which empowers the FDA to regulate the manufacturing and the sale of tobacco products. Family Smoking Prevention and Tobacco Control Act will finally take action to curb tobacco use and increase regulation of these deadly products. This law, though, don't forget, was decades in the making. 2 decades ago, I mentioned this hearing. I sat my first year in Congress, on the first or second year, in the House Energy and Commerce Committee. Chairman Henry Waxman from California, Democrat, first brought the leaders of the 7 big tobacco companies to testify about whether tobacco is addictive, whether it's marketing targeted children. These 7 tobacco executives raised their right hand, famous picture, front page of most newspapers in the country, pledged to tell the whole truth, nothing but the truth to this committee. Then they lied. Under oath, they said nicotine is not addictive. They knew nicotine was addictive. Their own tests showed nicotine was addictive, but they lied to the American people. Their testimony strained the imagination. By enacting stronger regulations of the tobacco industry, we help decrease the rates of respiratory and cardiovascular disease and cancer. We reduce the risks associated with tobacco use. For example, smoking rates in the U.S. are down from 25% of the population in 1990 to 19% today, from 25% to 19%. That is a huge public health victory. Not good enough, but a huge public health victory. Other countries with strong anti-tobacco laws, England, Canada, Australia, are seeing similar successes. Currently, of the world's 1.3 billion smokers, 80% live in low or middle-income countries. It's proven that anti-tobacco laws actually help curb this epidemic. America has a moral imperative to stand for global public health. Besides the 1 million people in the world predicted to die 1 billion people in the world predicted by the World Health Organization to die this century from smoking, there are secondary costs, including agriculture, for food being diverted for tobacco fields and money spent by often malnourished people on tobacco rather than staples they need. It's no accident that tobacco's predatory marketing strategy involve appealing to citizens who can least afford to waste tight family funds on a preventable addiction to tobacco. In Ohio, health care costs directly caused by smoking are more than $4 billion, $1.3 billion of that paid by Medicaid, by taxpayers. Our overburdened Medicaid program simply can't continue to bear the brunt of these costs. We're all affected by tobacco use. Consider this. In Ohio, the cost to taxpayers of government-related tobacco expenses add to a virtual tobacco tax on each Ohioan of about $600 per household. How does that work? People that smoke, they end up spending more time in the hospital. They end up with more diseases that are and illnesses that are expensive to treat. That comes out to about $600 per household, paying for those, whether you smoke or not, paying for that cost. We can't afford those costs in human life and to society if tobacco companies have the ability to challenge public health efforts under trade laws. We've made headway against this plague in America. Big tobacco has turned to trade deals. Big tobacco, amazingly enough, you wouldn't have predicted this 30 years ago, big tobacco typically has lost fights in the Congress. Big tobacco used to be like the NRA, they used to be like the Wall Street in that they rarely lost any big fight in the United States Congress. But they have in the last 20 years because increasing numbers of Americans have understood how big tobacco plays, how the way they lobby, the underhanded way they market, how they've marketed to children. We've stopped a lot of that. So what does big tobacco do? Now they've turned to trade deals as the most fertile avenues for defeating international public health efforts. Understand this, tobacco industry has deliberately made trade laws its new potent and legal weapon. Last year, the United States Trade Representative, and here's the key part of this, proposed a safe harbor provision that would have significantly limited efforts by big tobacco to challenge anti-tobacco efforts under trade rules created by the Trans-Pacific Partnership. They created a safe harbor provision. However, the right thing to do, the administration was standing up to big tobacco against the wishes and lobbying efforts of big tobacco. However, last month the administration changed course, arguing that the United States can best balance the priorities of public health advocates in business by not excluding any one product, including tobacco, from rules of the trade agreement. So rather than giving tobacco the safe harbor, they said we're not going to do it for anybody, the safe harbor to protect public health. In my view, this desire to strike a balance on a public health issue like tobacco is questionable, particularly when there's clear evidence that tobacco causes cancer and heart disease and lung disease, and as we've said, tobacco use is the world's leading preventable cause of death. My concerns are shared by leading public health advocates, the American Cancer Society Cancer Action Network, the American Academy of Pediatrics, the Campaign for Tobacco-Free Kids, longtime anti-tobacco voices like the New York Mayor Michael Bloomberg. Some will say the current U.S. tobacco proposal recognizes the unique nature of tobacco products, but neither the current nor the original U.S. proposal would prevent the most serious threat posed to global public health, the tobacco industry's ever-growing use of something called investor-state disputes or country-to-country disputes cases arising over tobacco product measures. In other words, since NAFTA, and I was talking to the presiding officer, Senator from Delaware, about this a minute ago, since the North American Free Trade Agreements, companies have been empowered to be able to go to a trade court in challenge of public health law. So if there's a strong environmental law, as there was in Canada about additives in gasoline, a company that made those additives in Richmond, Virginia, sued the Canadian government saying that their public health law banning this substance in gasoline, their public health law it hurt their business and was therefore an unfair trade practice. That's an example of what investor-state lawsuits allows provisions in these trade agreements. We're afraid that tobacco companies would do the same thing. For example, Australia's Tobacco Plain Packaging Act of 2011 is already under challenge under both the Australia-Hong Kong bilateral investment treaty and a separate World Trade Organization dispute settlement proceeding. These cases are pending despite the fact that Australian courts, locally controlled laws, determined laws, locally controlled courts, all in Australia, that Australian courts already held in favor of the plain packaging law. So what we're allowing is when a company has a strong public health law, if we in the United States write a strong public health law on tobacco or on clean air, on safe drinking water, the courts of the United States said this is constitutional, it should stay in effect. What this trade agreement would do is allow companies in other countries to sue the United States government to undermine and weaken our public health laws. The similar cases launched against Uruguay over its proposed graphic warnings proposal on cigarette packages and advertisements have happened. So Uruguay has passed strong warning signs, warning labels on packages of cigarettes, but they have been challenged by tobacco companies in other countries. Why should a tobacco company be able to tell the people of Uruguay that their law shouldn't stand in a trade court? I mean, what is sovereignty all about? The bottom line is the tobacco industry will use every weapon in its arsenal. They did it in the House of Representatives. They did it in the Senate. They did it at HHS. They did it at the FDA. They've done it wherever they can. They'll use every weapon in its arsenal. Fortunately, unsuccessfully, recently, much more successfully 2 decades ago. They'll use every weapon in their arsenal to protect their packaging and advertising, which is seen by millions around the world each day. It's used to attract new customers, replacing those that inevitably they lose. Unfortunately, these investor-state challenges are being used by companies around the world more frequently. The UN Conference on Trade and Development notes that the 62 cases initiated in 2012 are the highest number of cases ever filed in 1 year. Allowing private enforcement of investment rights outside of domestic legal systems can undermine and pose serious threats on public health, the environment, and consumer efforts taken by our trading partners as well as our own agencies. Americans are willing to support international trade agreements when there's a clear public good. But public confidence in international institutions and agreements is quickly diminished when we so clearly elevate corporate interests ahead of public health, ahead of the environment, ahead of protection for workers, ahead of public safety. In the case of tobacco, of all things, such an upside-down approach will lead to greater public health risk, disease, and premature death. Americans don't expect our trade negotiations to result in a situation that makes tobacco regulation in the U.S. and around the world more vulnerable to challenges. I hope the Obama administration will put forward a new proposal will give favorable consideration to proposals of other trade partners that reflect not only the American but the global consensus on tobacco priorities as they relate to protecting public health and the common good. Let me close, Mr. President, with repeating something that I think is particularly important. I remember my first understanding of this in the mid-1990s when we were told 350 to 400,000 people die from tobacco use every year. And then we examined and listened to the tobacco companies talk to, originally deny, then acknowledge their efforts to sell to children, to 12-year-olds, to 14-year-olds, to 16-year-olds with very, very sophisticated, high-powered marketing techniques, mailings, television and radio initially, but mailings in other ways, handing out cigarettes, billboards near playgrounds, billboards near high schools. So you think of that. When you fundamentally understand the way tobacco works, the way tobacco marketing works, is they lose 400,000 customers a year, and the tobacco companies have to find 400,000 new customers a year. They'll do anything to find those new customers. They'll aim at children. They'll aim at 16 and 17-year-olds. They'll aim at the poorest people in the world. If you're an Indian public health official, or you're a Chinese public health official, or you're a public health official in Bangladesh, you got lots of problems about cholera, about typhoid, about malaria, about AIDS, about tuberculosis. You probably don't have the efforts to fight back against big tobacco. We in this country have put a premium on public health efforts against big tobacco. In those countries, their efforts have to be against these terrible infectious diseases of tuberculosis and malaria and AIDS and cholera and typhoid and all those things that they simply can't fight back on tobacco. That's why it's up to us in our efforts in these trade agreements to really stand for something, to stand for public health, to stand for fairness, to stand up against big tobacco, and to do the right thing. President, I yield the floor. I suggest you have the floor.
Clerk will call the roll.
Mr. Alexander.
We heard senators this afternoon talking about amendments to the energy efficiency bill that the Senate's been debating. During opening remarks in the Senate this morning, Majority Leader Reid spoke about the importance of moving forward with the bill and encouraged Republicans not to delay work on the bill by offering non-germane amendments related to health care, saying, quote, "We're diverted totally from what this bill is about. Why? Because the anarchists have taken over. They took it over the House, and now they've taken the Senate." That's a quote from Leader Reid today. In addition to House Speaker John Boehner, Democratic leader Nancy Pelosi also reacted to Russian President Vladimir Putin's op-ed in the New York Times, saying she totally disagrees with him and says that America is an exceptional country. Representative Pelosi also commented on the House Republicans' continuing resolution to fund the government past September 30th, calling it a job killer.
Good afternoon. As some of you know, earlier today, there was a bipartisan leadership House and Senate meeting in the Speaker's office. As I said to some of you coming out, I thought it was constructive and productive that we came together, that we listened to each other, and I think that candor saves time. So I think that in that respect we have made some progress in understanding where we all are as we go forward with the continuing resolution and the debt ceiling. I think I referenced it as more than one manifestation of the budget debate. Kind of losing my voice. Without going into what we discussed at the meeting beyond that, I want to say that democratic principles have always been clear. We're focused on creating jobs, growing the economy to create jobs. So any approach to a continuing resolution or a debt ceiling lift has to be about creating jobs. We're prepared to find common ground to keep the government open and not default on the debt, and that's really important to job creation. And Democrats know that we have to get rid of sequester because it will cost, according to the CBO, as low as 900,000 jobs, a high of 1.6 million jobs this time next year. So say it's around 1 million jobs, take the lower side of it. That's a job loss that not only our country cannot afford, but America's families cannot afford. Here we are, out of session for before lunch on Thursday, because yesterday Republican leaders were forced to pull from consideration their continuing resolution. That would be the resolution to keep government open. We already know that House Republicans want to defund the Affordable Care Act and continue the very destructive sequester, again costing 1 million jobs just this next year. But I think it's important to note, you know it's a job killer. You know what they're trying to do, what it would do. But here's some other things. Their CR proposal would wreak havoc on Medicare. It's really important to note this because I don't think much has been said about it. No longer would we be able to provide services to millions of seniors. It just won't work. What they're doing just won't work. The fraud work, to end fraud in the Medicare system, would stop, and the increased payments for Medicaid primary care physicians would end. And that's really important. If we're going to provide services to people on Medicaid, we have to have primary physicians who will do so, and the increased payments for them would end. So this is nasty. It has tentacles that affect in a negative way many aspects of American life. Now Americans face the prospect of another Republican-manufactured crisis to shut down the government. What's interesting to note is the proposals the Republicans are putting forward are not proposals, continuing resolutions to keep government open. They are proposals to shut down government. They know that. They know that what they're proposing is not going to pass the Senate or be signed by the President. So why don't we just save time, be constructive, I respect the fact that they have the Democratic majority. We all respect that the President has the signature, that the Senate has a Democratic majority but requires 60 votes. So everybody has to respect the role that everyone plays in this. But the most important thing we have to know and consider is that we are here to do a job for the American people. And just because you're an anti-government ideologue who has landed in Congress doesn't mean that you should be shutting down government. We have a Democratic alternative. We've tried 7 times. Now we'll try an 8th time to have it considered. And that is what you've heard proposed by our ranking Democrat, Chris Van Hollen, on the Budget Committee. It replaces the destructive sequester. It creates jobs and accelerates economic growth, investing in infrastructure and Make It in America, et cetera, and reduces the deficit in a balanced way. Just think, again, getting back to the sequester, up to 1.6 million fewer jobs by this time next year. Thousands, tens of thousands of kids forced out of Head Start. Seniors kicked out of Meals on Wheels, to the tune of millions of Meals on Wheels, and investment slashed in research and technology. Was it about $6 billion slashed from the National Institutes of Health? That is devastating. So we're asking for a vote for our positive agenda, balanced, job-creating, make it in America, reduce the deficit. We're hoping that we have that opportunity. Instead of giving us a chance to do that, yesterday, for the 41st time, the Republicans voted to defund or undermine the Affordable Care Act. So in any event, just on the timing, my understanding is that the Republican leader has said that members should be prepared to be in the week after next. Mind you, we just came in a few days ago. We're already out of session by noon on Thursday. We come in next week, and we're scheduled to be out the following week, which is the week before the end of the fiscal year. Again, I'm calling upon the Republican leadership to keep the House in session so that we can get our work done. And that's not just the work about the CR and the rest. It's work about immigration. We have to pass comprehensive immigration reform. It's about a farm bill. We need to pass a farm bill for the American consumer, for America's farmers, and for all of those who depend on the nutrition programs that are contained in it. The path that they are taking by slashing 50% of the nutrition program is well, it speaks for itself in terms of how mean-spirited it is. However, that is their path to, perhaps their path to, if it passes, to the conference table. So at least we will be getting to the conference table on that, even at the price of 50% of the nutrition programs. I bring up these other subjects because we're working on all of these subjects and have been. The issue of the moment, of course, of the day is Syria. I'm very proud of the President. I think on Tuesday night he laid out in very clear terms how the Assad regime's use of chemical weapons impacts our national security, why the United States must lead the world in holding the regime responsible for gassing more than 1,000 people, including hundreds of children. One thing is clear, undeniable. The President's credible threat of military action has brought parties to the table to seek a viable diplomatic solution. It's a tribute, I think, to the strength of the President, to his strong leadership, that he was willing to make the strike and strong enough to say no to the strike if there is a viable diplomatic solution.